Today, you're going to hear from a divorce attorney who won cases for years before realizing the system wasn't built around people or their humanity. She saw that even when someone won, families were still losing when what matters most. So if you're facing divorce, this conversation may protect you from mistakes you don't get to undo. Welcome back. Welcome to Divorcing Strong, the podcast that pulls no punches when it comes to divorce. I'm Becky Sampson, better known as Bulldog Becky Brockovich, and I'm here to give you the straight talk, the strategies, and the subpoena secrets you won't hear anywhere else. With expert guests and proven advice, you'll learn your rights, your options, and gain your power that encourages a fair and equitable outcome. Divorce doesn't have to break you. It can build you. Let's get to it. Well, welcome back, everybody. And I'm back in studio today. Oh my goodness, it's been a crazy last couple of days. But I got home really late last night and I'm grateful to be back in the studio. I did an amazing opportunity to present to people last night who have been affected by abuse and share my story. And it was fun. I got to bring my mom with me and everybody loved my mom. They're like, "You're Becky's mom." I thought that was so cool. But I just want to welcome you to another episode of Divorcing Strong. I'm Becky Sampson, your host. And as always, I bring experts together so that you can be informed and gain the knowledge that you need to so you can divorce strong if that's unfortunately what you're having to deal with. And today is it's amazing to me. I was going to say, it's amazing to me, the network that I'm building. And I say this all the time, but it is very, very important that you get in front of the right people. And that is my intention with the Divorcing Strong, is to bring the right people into your network so that you know that there's people out there that are going to advocate for you. And today I'm really excited because my guest and I have kind of gone back and forth. We've been waiting for this perfect time for us to get together. And just grateful because anytime a divorce attorney allows me a little bit of space into their world, I love to pick their brain, and especially for you as the listener, because I want to be able to ask the right questions so that you can walk away more empowered. So with that, on today's episode of the Divorcing Strong, I'm joined by Amanda Mason. She's a woman who knows exactly why divorce so often feels like emotional and financial warfare, because she spent most of her career inside of it. Amanda graduated from the University of Arizona College of Law in 2003 and built her career as a divorce litigator in the traditional family court system. For years, she did what many attorneys are trained to do: fight hard, push forward, and win cases. But along the way, she began to notice something deeply unsettling. Even when her clients won, they often lost everything else that mattered. So 6 years ago, Amanda made a courageous pivot. Instead of accepting the damage as inevitable, she set up the design a better way. Today, she's the CEO and co-founder of Solagree, a nationwide non-adversarial divorce model built to help couples resolve conflict with integrity, clarity, and far less collateral damage. She also remains a partner at Mason & Smith, giving her a rare dual perspective on both the old system and what's possible beyond yet. Stay with us, because if you're going through a divorce, this conversation may change the path that you choose next. So with that, I want to go ahead and welcome Amanda to the show.
Hi, thank you. That was all very well said.
I love doing those intros. I say every single one. I love it because I like putting the humanity of what you do and why you're passionate, but I really like to hear it from you. So that's kind of my first question is, what got you into this space? What's your backstory of becoming an attorney, and then most importantly, starting Solagree and helping do it a different way for people in this space?
Yeah. Yeah, so becoming an attorney, gosh, well, you said 2003, so it's a long time ago now. I can scarcely remember. No, I think it was one of those moments where I had graduated college early at the age of 20, and I was just, I was pregnant, I think, when I decided to go down this path with my first child, my daughter. Whose father I ended up unfortunately having to go through divorce with at a later date. But yeah, so I think I was kind of at that moment going, what's next for me and how can I bolster my career? And so graduate school was a logical choice. I took a practice LSAT, did very well on that. So that seemed to be, the next best option for my path. And yeah, I was 8 months pregnant when I took that darn test eventually. So it was really a bit of an achievement. I had my son during law school. So,
Wow.
I was very, very young. When you're really, really young, you feel like you can conquer the world. And I guess, in a way, I'm trying to conquer a world now. So I feel blessed to have that energy. But yeah, not a specific path for me. I didn't go into law school saying, I want to practice divorce law. Like most attorneys, my path sort of found me along the way.
And by the way, that's very, very normal for all the attorneys I bring on here, because they're like, no, I did not wake up one day and it found me instead of me finding it. Yeah, mostly.
Yeah. Yeah. I think I thought I was going to do international law, and I'm not even sure I really understood what that meant. I think that just sounded, I don't know, kind of sexy or something. But, no, and I did find the right path for me because, helping people was always very important to me in my career. And let's be honest, practicing divorce law is lucrative in its way. So that, has its own rewards. Yeah. So then as I got deeper and deeper into it, look, I was great in the courtroom. I still am. I still have some cases. But I just saw so much injustice happening. And I realized that setting, that adversarial someone versus someone setting, is the worst thing to do to a family. These are not criminals. The adversarial justice system is great for certain things. Corporations versus corporations, perhaps, although I still think that most things could do well with arbitration and some alternatives, but it really absolutely is not where families belong. And ultimately, I unfortunately experienced that on a personal level when I had my own custody trial, and I was practicing attorney and took the stand and everything. So
yeah, how
really
about that?
tried to inform me.
As I had a guest many months ago. She also, I think she had like 6 kids or maybe 8 kids while she was going through law school. And she realized that going through law school, she didn't learn a lot about the family law or even how to get divorced through that.
Oh yeah, no.
Yeah. So, I mean, is that one thing that kind of drove you into this space, is because you were having your own personal experience and being a lawyer, you're like, dang.
Well, I was already in this space, within, the early stages of my family practice when I went through it. It definitely empowered my voice in terms of the counselor at law role. I think that, despite the fact that more cases than I'd cared to admit because of the system did still end up in court.
Right.
I really tried very hard to help my clients see through their feelings and get to a pragmatic, at least consideration of alternative decisions that they could make. It's very hard though. And it's the system that causes that dynamic.
Yeah. I mean, and so one of the things that you really kind of pivoted you out of necessarily the court thing, what did you find that was broken within the system?
There's 2 major aspects that are broken with the system. So I'll talk about the actual system itself, which is the court system. A court system is a government operation. Let's never forget that. It is a system whereby people are stuck in a bureaucracy. They take a long time to get to a court, to a judge to make a decision. Our judges are terribly overworked, which, being human, has side effects. And so I watched my clients, other clients that weren't mine, trust me, it wasn't just mine, be mistreated and mishandled in the court system. And quite often I saw attorneys being mistreated in the court system, by each other, by the personnel, by the judge. And and by the way, I'll say less the personnel than by each other and by the judge. Shout out to the amazing courtroom personnel out there.
Yeah, I was going to say, like, what do you think is really the main cause of that?
Yeah, and I think it is the overburdening of the system and the lack of efficiencies built into it. Because think of this, a judge is seeing people on their absolute worst day. They're seeing the clients having the absolute most horrible thing that's ever happened to them unfold in front of them. That's going to cause you to feel jaded about it. And they're seeing us attorneys in our most competitive mode. And let me tell you, as soft and touchy-feely as I can be about Solagree, when I am in that fight mode, it is a different mentality. And I've seen that difference with the attorneys who I work with in the Solagree program too. You can't help it. You are hardwired as a litigator to get into that somebody versus somebody, I got to win this mode.
Is that something that they teach you in law school, by the way?
Not really. I think that's something that's inherent. Yeah, there's two different types of lawyers. There's litigators and non-litigators. And if you're a litigator, you just have it, or at least you'd better have that because that's your job.
Yeah, that is your job. And I think the interesting thing is my experience, and you don't know much about this, but it was interesting because I had 21 hearings during my 3.5-year court case getting divorced. I know. And I was representing myself for most of it, not because I wanted to, but it was because I had to. And it took everything out of me to still advocate, because that fighting, that like, we want to fight, right? I'm a fighter. You push me up against the wall, I'm going to fight. Sure. However, I learned to advocate and still do the best I could to keep that realistic thought process in me going, you know what, yes, he's under a lot of pain. I'm under a lot of pain, but the system doesn't see that pain. And so it was hard as a litigator, or not a litigator, but somebody that was representing herself in that position. And because it's a real temptation. And I can see that even for me, when I help advocate for people, I'm just like, I want to go fight for him, but that's ultimately not what wins. And so talk a little bit about that and how that really fueled what you're doing now.
Right. So one of the things that frustrated me the most is when I could tell that there was an obstructionist attorney preventing the other person from having the same kind of conversation I was having with my clients. And it's very easy for an attorney, because of being someone versus someone, to believe everything their client is telling them or adopt their client's position internally. And if you can't maintain that objectivity, it's a very difficult skill to build, by the way. If you can't maintain that objectivity, you can't really treat what is the actual root cause of the symptoms really that your client is experiencing. And I just knew so often that if we could just almost do away with the attorneys and have someone neutral guide the clients in a better way, that this thing would go away faster. And again, I don't mean that attorneys are giving bad legal advice. I just think that there are times when they are not capable of really putting their own emotion about the case in park to give their clients better objective advice, which is really what they need.
Well, and attorneys are real people too, right?
100%.
I had a guest on my podcast a couple of weeks ago, or maybe it was last week, I can't remember. But he said honestly, and this is not the case, and this is not to throw attorneys under the bus, but sometimes attorneys can really get in the way, and it drove up the cost of his of his divorce. And after it was all said and done, him and his wife, super high conflict divorce, because the attorneys kind of went after each other. And afterwards they sat down and go, that's ridiculous. Like, we did not need to do that. And I think that that's kind of where you're coming from is that, look, there's alternative regardless. And again, everybody's human in this equation. Attorneys are human. You're human. Mediators are human.
And if I could just speak to that. Yeah. I mean, if I could just speak to the humanity. So I did not create this process just because, gosh, we attorneys stink. Let's throw us all out with the bathwater.
Right.
I created this process not only to give the clients a better experience, to get out of that mode faster, but also as a gift to my co-counsels to all of the wonderful men and women out here who are doing this really hard work.
It's hard work.
That they have a better way of going about their practice. They can represent more people. They can do what they do best and just go to that place where they're giving good advice, because that competition piece of their brain is dialed down. And it's meant to be a more satisfactory process for the professionals who bring their clients through in this way, because of the mental health strain that it takes, because of the substance abuse issues that it can lead to, suicides. I mean, really, being a litigator in this space is so hard. So, I just, I was moved for both the clients and the attorneys to do something better.
Yeah, just have it be a more pleasant experience, right? And feel like you're making a difference instead of ruining your families or ruining the families. Like they can come out of a really high conflict divorce that way. So what is the process that you take people through? I mean, you said you were not the originator of this, or were you?
This is mine. This is my design.
Okay.
This is my brainchild, my baby. So what I did was I looked at other methods that exist out there in terms of alternatives, right? We know we want to avoid court because that's the worst case scenario. Yep. What were the alternatives that existed out there? What was working and what wasn't working about them? So the alternatives being mediation, what I call naked mediation, which doesn't have the arbitration piece that our program has. Anyone can walk away at any point. Collaborative law, well-intended. We're going to try and do the best we can. Anyone can walk away from the process at any time. So there's two big threats in a settlement negotiation. There's the threat to walk away from the negotiation process and blow everything up into the expensive courtroom battle. As long as that exists, whether it's real or perceived to exist, people are going to be in their fight or flight mode and not be able to do their best work. Again, we're trying to get them into the right mental space in order to be able to intellectually manage these circumstances. The other big threat is the threat to drag it out endlessly. And they're kind of two sides of the same coin, but those are the big threats that loom out there. And we had to have a system that dials it down. So we bring our clients through 3 phases very methodically. We're getting them educated up front by, in phase 1, having them work with a certified divorce financial analyst, and on our parenting track, a parenting intake specialist. And then they go to mediation, and then they go to arbitration. So everyone who comes through our program has to sign a private arbitration agreement. And that is the only way that we can actually keep people contractually bound to go all the way through the process to completion.
Okay,
So
wait. So for the person who's watching this and has no idea what mediation means, I know we've talked about this on the podcast, but the difference between mediation and arbitration, because this is what really sets you apart from what a lot of people do, and even in collaborative divorce. So
correct.
Kind of explain that, the mediation, and I like to hear that you're preparing them mentally and financially for that mediation, because many people I went into mediation without all the information. That's why I subpoenaed. Right. I was like, how do I mediate something that I don't know? So it sounds like you've got professionals along the way that prepare them for that mediation. So talk a little bit about mediation, and then what would be the benefit for arbitration, because those are 2 different things.
Yeah, so mediation is going to be with an attorney mediator, someone who has a family law background, who understands what's at stake here, and they're neutral. And they work with the 2 parties to take everything that they've learned and all of the early areas of agreement that they've gotten in our phase 1, working with those early professionals, and try to help them bridge the gap, to help them resolve for themselves through skillful discussion, and in our case, always in a virtual setting, to help them decide for themselves. So then the mediator creates a summary of all of the wonderful areas of agreement. And to the extent that they simply can't get to a final agreement on a piece or 2 of it, first of all, we've got it whittled down in our program to just that, a piece or 2. There's the safety net of an arbitrator, because if they can't solve absolutely everything, someone has to decide for them. You've got a judge option, or you've got a private mediator option. A judge, we've talked about the problems, the limitations with a judge. And by the way, a lot of them come to the bench with no family law background. Facts. With an arbitrator, our arbitration.
Yeah. So you're saying that most family law attorney, or judges, I should say, that hear family law cases don't have a background in family law.
But most of them have come to Yeah, so most of them have come to the bench and they learn family law from the bench. They are, they were prosecutors in public service, those types of people. I mean, it does happen, but for the most part, judges, come to the bench with no family law background, a lot of times no civil law background. So they really are, they're learning in the worst setting possible. Again.
Right. So that is another reason why you do not want to get to that point where a judge who doesn't have the experience necessarily, I'm not saying he doesn't, or she doesn't, but you do not want to get to the point where they're deciding your financial future. You want to keep that within your control or your influence when it comes to your future. I mean, that blows my mind. I didn't even know that.
I mean, and there are many well-meaning judges out there, and some of them do learn it fine, but again, you're gonna have to wait a long time to get in there, and you're not gonna have as many tools to resolve it. So an arbitrator, by contrast, is not going to have, first of all, an adversarial setting. They're going to arrange for a relaxed conversation with, in our program, virtually, people are in their safe spaces. And these are people that we have vetted for not only their experience in family law, but also their eagerness to work with these clients and treat them with dignity and treat them with respect, because that's the piece of it that I miss a lot in the court system.
Yeah, because I mean, we even talked about that last week is that people going through divorce, we need validation, right, for how we feel. And when you have a trained professional that actually knows how to do that in this setting, it really is a game changer in order to help you navigate through those crazy waters. And so the arbitration, you're saying, is more binding, right? So it literally is the step underneath going to a judge. Once you make that decision, it is a binding agreement through the court system. Is that correct?
That's right. In most states, that's going to result in your binding document. At the end of the process, whatever process you like, you have to have something that binds you to it. Better to have something that was crafted mostly by your design in an efficient, predictable timeline, so we can get you in and out and done with this faster. To your point with the couple you're just referencing, the moment it's done, it's like the clouds part and you can see again, and you haven't realized how much it's been hanging over you. Let's get that done. Let's get you moving forward. I don't care how much you hate each other. You can hate each other, but why spend another minute or another dollar fighting each other? Let's get you on to the next phase of your life. And the other benefit of arbitration is that these are people who are subject to our rules. So Solagree administers rules in a high integrity setting. The arbitrators sign a contract with us that they're going to adhere to our rules of professional conduct. They sign with us that they're going to follow our standard ground rules in administering the process, and they're accountable to us. We act as their case manager. So there's an immediate consequence. If they disrespect one of our clients, they don't get hired again. And that's huge in terms of a contrast with a judge, right? And the benefit of that is it doesn't happen, right? Because they want to do this work. They've come to us because they're eager to help the people and shift into this way of conducting family law.
And so, are they working exclusively through you? Do you have an exclusivity, or they can?
No, we don't have any exclusivity. Okay. So one of the benefits is that we have low barriers to entry in terms of those kinds of requirements for our professionals, because I want the freedom to bring people on who I know are the best and say to them, don't worry, keep doing everything else you're doing, but just do this in this way. So yeah, no exclusivity for them, high barrier entry in terms of qualifications, but we want to make it easy for our professionals.
And so are you in all 50 states, by the way?
We are expanding very quickly. We're not active in all 50 states, but we anticipate by the end of 2026, we'll have all of our panels in every state complete, meaning all of our professional panels who are licensed within each state, ready and available for the clients to be able to come to us. So we're close in most states. I guess I can put it that way.
Okay, so if they contact you, if they want to reach out to you and maybe go this route rather than the court route, you'll let them know what state you're in and qualified in. Yeah.
So they need to just let us know what state they're in, and then I can say, yep, we're active there, or we're going to be active as of whatever date it may be.
Okay, so what surprises you most about people that have gone through your process?
Oh, Well, I'll tell you, it hasn't been too much of a surprise in terms of their experience because I know that they recognize that they've come through a better process. I think one thing that surprised me was the range of couples coming through. So it's been broad. We've had a number of gray divorces, not a term I love, but it's out there. I can't change it. Come through. That's, over 55, 60, however you define it, divorces. They don't want to spend their last, few years being tainted by a nightmare. We've had very diverse clients in all the ways you can anticipate. So minority clients who are traditionally leery of government systems are very interested in this process, and we're here for that. People with who feel they have very personal needs, and then also high net worth clients who don't want the attorneys salivating over getting a piece of that pie, yep. Right? Yep. They're leery of it too. And the benefit too with private arbitration is the confidentiality and privacy that it involves or that it allows, so that if you have assets that you don't want to be, spilled into a courtroom setting, that's one of the biggest benefits, particularly to our higher net worth clients.
So here's a question just selfishly because of subpoenas, right? Yeah. But when they're going through your process instead of going through the court, do you guys still do discovery and you still do subpoenas? Or are people more willing to give the information that they need because it's a more relaxed process, I should say?
Yeah. So we try not to make formal discovery a thing because that's one of the sticky thickets. And by formal discovery, I'm talking about interrogatories, requests for admissions, requests for production of documents. We try to get in phase one, the information exchange as tailored to the couple as we can and as comprehensive as is needed. That said, the tools are there. If we've got a high conflict case where we know there's going to be subpoenas needed, or, sometimes maybe a subpoena is the most efficient way to get a certain set of documents, that's still available. It's just a little bit of a nuanced question depending on which state we're operating in, how procedurally we go about that. But yes, this is not meant to limit the tools in the toolkit. This is meant to expand and create more flexibility for the use of them.
Yeah. And I would imagine, it's funny because I was talking to an attorney the other day and he's like, I had to subpoena records because my client wouldn't give them to me or they couldn't provide them. And I was like, wow, I've never even thought about that. You know what I mean? You're subpoenaing the records for your client because they didn't have the time or didn't know how to process it or whatever, find the information. So subpoenas still are an important part
absolutely
of this process. What would you say to somebody that says, oh, there's no way that we're going to be able to avoid, I know my spouse, they're never going to settle. They're never going to be able to really sit down and have a conversation. They just want to fight. What would you say to them? And would this process still work for them?
Yeah, it would definitely still work for them. So, again, if you can't get any agreement in phase one and phase two, you end up in a better position going into the decision-making process. That's the point. You still have to have someone ready to decide at the end of the day. If your husband wants to fight about, or your wife wants to fight about everything, you know what? They could still have that argument. They just would do it in front of an arbitrator and get it done faster.
Nice. And is that something that they agree upon at the very beginning of the process, that they'll go to arbitration, not to court?
That's the glue. That's the secret sauce of Solagree.
Yeah. See, that is the very thing. So when they first start working with you and they first come through the door, that's the agreement that we're going to go with the arbitrator, not the court. So that's right. That's brilliant, Amanda.
Well, it is great. It is great. And there's the science behind it. Again, it takes them from the beginning out of fight or flight mode. They know that those two threats don't exist because no one can blow it up in a court and make it last for 3 years and, $50,000, $100,000 or more. And we're going to keep it moving. So we've actually got anti-ghosting procedures in our standard ground rules. We've got ways that we can force people to continue working through the process. So, and faster answers to the smaller questions that, may be the most pivotal questions to make the whole thing settle. So it's just really a wonderful, flexible procedure, but that at the end of the day has a lot of integrity to it.
Yeah, no, I think it's perfect. And I think the thing I also heard you say is that because it's on a smaller scale, because sometimes you can get in the court system and there's a million different attorneys, a million different cases, a lot of different judges, and then you get lost. Your case gets lost in a lot of the mix, but you have very detailed attention to not only the arbitrators, but your intention is to move them through this process as quickly as possible, which is not how the legal system and the court system is. So
Right.
I can see that you saw that as an issue and a problem, and now you're creating a solution to that. Because really, in the end of the day, it's so much easier if we can just move through that, reset, start the chapter, turn the page, start a new chapter, and move on with our lives. Because I don't think anybody wants anybody to go through divorce, but if it's going to happen, make sure it's thorough, because you don't ever want to get on the other side and be like, oh, I wish of this and I should have done that, or I should have done this. And no, you want professionals to be able to guide you through that. And that's the beautiful, I'm also a trained mediator, because I was learning about mediation while I was going through my second divorce. And, I don't do it. But it is so magical when you get somebody that really knows and is so professional to be able to get someone that's not able to even be open to any possibility, to then seeing this beautiful miracle happen through mediation and arbitration. And I'm sure that feels, maybe I should ask you that question rather than putting it in your words, but does that feel like you're making a difference in this system that really is broken?
Best feeling in the world. Best feeling in the world, having that breakthrough, getting people to the end, and, sometimes they're super high conflict, but we're able to get them to at least validate each other's positions. And then it's like, off it goes. And especially when they come to mediation, understanding their circumstances. And that's such a difference from the traditional legal mediations where they're just lost. They come in, they're like, I don't know what's happening.
Well, and that's the thing, is that the courts now don't want to deal with all the mucky muck. And so it seems to me, at least in my case too, is that it was immediately we went into court and they're like, nope, it was mandated that we went to mediation. But then when we were thrown to mediation and I didn't have the information, I'm like, how do I need all the information. But the courts were so like, get into mediation, and so it was $3,000. It was a waste of time.
Wasted.
Even though I and his attorney both agreed that mediation probably wouldn't be the right fit. We were forced to do it anyway. But again, I love that you get them set up with all the information that they need to, so they're empowered to be able to make a decision during that process. That probably is one of the reasons why you move them through so quickly. So I love that. So how do people find you, or what's the process? Do you have a free intake, or do you have some kind of a...
Yeah, just shoot me an email, Amanda@solagree.com. You can go to our website, www.solagree.com, but shoot me an email and we'll get you set up with a free initial consult. We'll walk you through how the program works more in depth. We will give you all of the pricing structure that is flat fee and predictable. We'll talk about all of the a la carte options that exist in case you need to have those. And then you can have that conversation. I love the most when I meet with the couple together at first, because I know, even when I can sense all the tension in the room, I know we're going to get them through so much better off than they would be if they each just, started with their own attorney and came into the traditional process.
Well, and you're giving them hope, right? I love that you can bring them together and say, look, this can be a better process than what's out there. And believe me, I've been there. That's probably what you say.
I'm so sorry that you've been through it too, by the way. That's just,
well,
look at what you're doing with it.
Yeah, that's exactly what I was about to say to you, Amanda, is that because of what you've been through and what you've seen in the system, you're probably a lot like me. That's like, look, this is the problem. What's the solution? And how can I be a part of the solution instead of perpetuating the problems? Because it really is. People just don't wake up in the morning and go, yeah, I know everything about the court system. We don't think we're going to get divorced. Right. And then when you're faced with that, it's just so important that you understand the process, or else I know you probably feel this way too, is that hearing the stories of nightmare stories of people losing everything. And I just had one actually yesterday. I was at a Lowe's or whatever, and I ran into a guy, 38 years married, and he was left with nothing. And I said to him, like, He's like, I didn't want to fight. I said, I get it. I get it. And at least if you knew your options, you might have made different choices. And that's my big thing is that get the people around you to help educate you so that you can at least make an educated decision. And I love, love, love that you prepare them for that. Because I don't think traditionally attorneys have the time necessarily. It's not that they don't want to, but I don't think they're so, up to the gill with everything going on. They just don't have the time to really sit with people. And I love that you do that with your clients. And you also show respect towards your professionals that come in to support. And I appreciate that.
Absolutely.
A lot.
Thank you. Yeah. Thank you.
And you've turned your knowledge into something really powerful. And I'm really happy to be a part of helping you get nationwide and make this a big success. So thank you. So here's my last question for you is what does divorcing strong mean to you?
Divorcing strong. Oh, I like this question so much. Divorcing strong to me means you are divorcing in a way that maintains who you are at the core of your soul all the way through to the end of the process. Because as long as you can be yourself, you're going to feel fine and you're going to be able to move forward in your life.
I love that. Yep. It is all about coming through it better, not bitter. And I love it. And you need to know your values. And if you know what your values are, then you know how to advocate better for yourself. So thank you so much, Amanda, for your time. I know you're super busy and growing this business, and I appreciate what you do. And
thank you.
Yeah. So hold on one sec. So I want to thank everybody for another episode of the Divorcing Strong podcast. I have been Becky Sampson, your host. And please, also, I didn't remind you, but if you want to go to the free download where you can get your 100 divorce terms. Yes, that's 100 divorce terms, legal terms, so that you can understand how to navigate better through this process. And please reach out to Amanda. All of her information is going to be there in the show notes. I appreciate her time, and we'll catch you on the next show. Thanks so much. Thanks for listening to the Divorcing Strong podcast. This episode is sponsored by Only Subpoenas, where we make subpoenas simple, powerful, and 100% compliant. If you're having a hard time getting the information you need to settle for a fair and equitable divorce, let us help you. Whether you're an attorney or you're navigating divorce on your own, subpoenas can uncover the truth, secure the evidence you need, and level the playing field. To see how we can help, book an appointment by visiting our website at onlysubpoenas.com.